Please be seated. The sitting is open. La Cour.
The court meets today to deliver in open court its decision on the request for the indication of provisional measures submitted by Nicaragua in the case concerning alleged breaches of certain international obligations in respect of the Occupied Palestinian Territory. Nicaragua versus Germany. Judge Yusuf, who duly participated in both the deliberation and the final vote, is, for reasons made known to me, unable to take his seat on the bench today. I recall that on the 1st of March 2024, Nicaragua filed in the registry of the court an application instituting proceedings against Germany concerning alleged violations of certain international obligations relating to the Occupied Palestinian Territory. The application contained a request for the indication of provisional measures submitted with reference to Article 41 of the statute and Article 73, 74, and 75 of the rules of the court. In accordance with the usual practice, I shall not read the introductory paragraphs of the order, which set out the principal steps of the procedure in the case. I shall also omit or summarize some other paragraphs. I shall therefore begin the reading of the order at paragraph 13. In the order, the court begins by recalling that under Article 41 of its statute, it has the power to indicate, if it considers that circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party. In the present proceedings, the court considers that it must first ascertain whether Nicaragua has sufficiently shown that all the circumstances as they now present themselves to the court are such as to require the exercise of its power to indicate provisional measures. The court notes that according to Nicaragua, by providing weapons to Israel and by suspending the provision of funds to UNRWA, the United Nations Relief and Works Agency for Palestinian Refugees in the Near East, Germany has failed to comply with its obligations under the Genocide Convention and international humanitarian law, including the Geneva Conventions of 12th of August 1949 and the additional protocols of the 8th of June 1977 and its transgressible principles. Nicaragua contends that for the year 2023, the German government authorized exports of military equipment and war weapons worth more than 10 times the amount for the year 2022. The vast majority of which have been granted since the beginning of the military operation by Israel in the Gaza Strip. Nicaragua claims that Germany could not be unaware of the situation in Gaza, nor ignore the likelihood that the military equipment and weapons provided by it would be used by Israel, I quote, to bomb and kill thousands of Palestinian children, women, and men, end of quote. It also claims that Germany has not only violated its obligations to prevent and punish breaches of the Genocide Convention and or international humanitarian law, but that it is also, I quote, complicit in them by aiding and assisting the commission of those breaches, end of quote. The court notes that, in response, Germany first states that it has fulfilled the obligation incumbent on states parties to the Genocide Convention to prevent the occurrence of genocide by continuously using all reasonable means at its disposal to exert its influence on Israel in order to improve the situation in Gaza and furnish humanitarian aid to the population of Gaza. Secondly, it contends that the obligation that could be derived from Common Article 1 of the Geneva Conventions, incumbent upon non-parties to an armed conflict, does not obligate a state to refrain completely from providing military support to a state involved in an armed conflict. Germany further contends that it has stringent licensing standards to assess whether there is any risk of serious violations of the Genocide Convention, international humanitarian law, and other peremptory norms of international law by the recipient state. According to Germany, there is no evidence that the supply of military equipment to Israel by Germany would have contributed to an alleged genocide or to breaches of international humanitarian law. The court notes that Germany, as it has stated, is bound by the Arms Trade Treaty of the 2nd of April 2013 and by the European Council Common Position of the 8th of December 2008, as amended on the 17th of September 2019, which defines common rules governing the control of exports of military technology and equipment. The court further notes that, as Germany has also stated, the German legal framework on the manufacturing, marketing and export of weapons and other military equipment involves an inter-agency process with consideration by at least 2 ministries and potentially other ministries, depending on the content of the license application. Under this legal framework, there are 2 categories of military technology and equipment subject to licensing: war weapons, the export of which requires 2 licenses, and other military equipment, the export of which requires only 1 license. Under the German legal framework, for every license that is granted, an assessment is carried out by the German government to ascertain whether there is a clear risk that the particular item subject to licensing would be used in the commission of genocide, crimes against humanity, or grave breaches of the 4 Geneva Conventions. The court in addition notes that, as stated by Germany, there has been a significant decrease since November 2023 in the value of material for which the licenses were granted, from approximately 200 million euros in October 2023 to approximately 24 million in November 2023, to approximately 1 million euros in March 2024. The court also notes that since the 7th of October 2023, according to Germany, only 4 licenses for war weapons have been granted. 2 for training ammunition, 1 for propellant charges for test purposes, and 1 concerned the export of 3,000 portable anti-tank weapons. The court further notes that Israel had also approached the German government in 2023 for tank ammunition, and that no decision by the respondent has thus far been made regarding this request. In addition, according to Germany, the licensing for export of a submarine to Israel is currently pending, as only one of the 2 licenses required for this export has so far been granted. Finally, the court takes note of Germany's statement that 98% of the licenses granted since the 7th of October 2023 concerned other military equipment and not war weapons. With regard to Nicaragua's request that Germany, I quote, resume its support and financing of UNRWA in respect of its operations in Gaza, end of quote, the court notes that Germany announced its decision to suspend its contribution to UNRWA on the 27th of January 2024 in respect of its operations in Gaza. In this regard, the court observes first that contributions to UNRWA are voluntary in nature. Secondly, it notes that, according to the information provided to it by Germany, no new payment was due from the latter in the weeks following the announcement of its decision. Finally, the court notes that Germany stated that it has supported initiatives aimed at funding the agency's work, in particular through the payment of 50 million euros by the European Union to UNRWA on the 1st of March 2024, as well as providing financial and material support to other organizations operating in the Gaza Strip. Based on the factual information and legal arguments presented by the parties, the Court concludes that, at present, the circumstances are not such as to require the exercise of its power under Article 41 of the statute to indicate provisional measures. As to Germany's request that the case be removed from the list, the Court notes that, as it has held in the past, where there is a manifest lack of jurisdiction, it can remove the case from the list of the provisional measures at the provisional measure stage. Conversely, where there is no such manifest lack of jurisdiction, the Court cannot remove the case till that stage. In the present case, there being no manifest lack of jurisdiction, the Court cannot accede to Germany's request. I will now continue reading the order in English.
That in its order of 26 January 2024, in the case concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip between South Africa and Israel, it noted that the military operation conducted by Israel following the attacks of 7 October 2023 had resulted, and I quote, a large number of deaths and injuries, as well as the massive destruction of homes, the forcible displacement of the vast majority of the population, and extensive damage to civilian infrastructure, end of quote. In addition, the Court remains deeply concerned about the catastrophic living conditions of the Palestinians in the Gaza Strip, in particular, in view of the prolonged and widespread deprivation of food and other basic necessities to which they have been subjected, as acknowledged by the Court in its order of March 28, 2024, delivered in the same case. The Court further recalls that, pursuant to Common Article 1 of the Geneva Conventions, all states parties are under an obligation to respect and to ensure respect for the conventions in all circumstances. It follows from that provision that every state party to these conventions, whether or not it is a party to a specific conflict, is under an obligation to ensure that the requirements of the instruments in question are complied with. Such an obligation does not derive only from the conventions themselves, but from the general principle of humanitarian law to which the conventions merely give specific expression. With regard to the Genocide Convention, the Court has had the opportunity to observe that the obligation to prevent the commission of the crime of genocide pursuant to Article 1 requires states parties that are aware or that should normally have been aware of the serious risk that acts of genocide would have been committed to employ all means reasonably available to them to prevent genocide as far as possible. Further, state parties are bound by the Genocide Convention not to commit any other acts enumerated in Article 3 of this convention. Moreover, the Court considers it particularly important to remind all states of their international obligations relating to the transfer of arms to parties to an armed conflict in order to avoid the risk that such arms might be used to violate the above-mentioned conventions. All these obligations are incumbent upon Germany as a state party to the said conventions in its supply of arms to Israel. The Court reaffirmed that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the Court to deal with the merits of the case or any questions relating to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of Nicaragua and Germany to submit arguments in respect of those questions. I shall now read out the operative part of the order. For these reasons, the Court, by 15 votes to 1, finds that the circumstances, as they now present themselves to the Court, are not such as to require the exercise of its power under Article 41 of the statute to indicate provisional measures. In favor, President Salam, Vice President Sebutinde, judges, Tomka, Abraham, Yusuf, Shwe, Bandari, Iwasawa, Nolt, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi. Against Judge Ad hoc Al-Khassawi. I shall now call on the registrar to read the operative part of the order in French.
Par ces motifs, la Cour, par 15 voix contre 1, dit que les circonstances telles qu'elles se présentent actuellement à elle ne sont pas de nature à exiger l'exercice de son pouvoir d'indiquer des mesures conservatoires en vertu de l'article 41 du statut pour M. Salam, président, Mme Seboutinde, vice-présidente, M. Tomka, Abraham, Youssouf, Mme Choué, M. Bandari, Iwasawa, Nolt, Mme Charlesworth, M. Brandt, Gomez Robledo, Mme Cleveland, M. Orescu, Tladi, juge. Contre, M. Al-Khassaouneh, juge ad hoc.
The text of the order is available from today in TypeScript. It will be available shortly on the court website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.